Welcome to This Week in Education Law, where I share up-to-date court decisions from the perspectives of educational administrators and policymakers. This is episode 35. Can parents video record their child's individualized education programs, also known as IEP meetings? Is this protected by the First Amendment? I'll use a recent case to answer those questions. A father had a child who received IEP services from a public school district. Amid the COVID-19 pandemic, in two online IEP team meetings in February and March 2022, the parent discussed his child's new IEP with relevant school district employees. At those meetings, although the school district had previously argued to remove the student from IEP-based special education services, several school district employees admitted that the school district and the administrators of special education had no data about which to base their opinion that this child should be removed from these services, and that teachers who performed evaluations on the child that resulted in findings contrary to the school district's position were later asked by the school district to double-check their evaluation. But teachers whose evaluation results supported the school district's position were not asked to do the same. The father alleged that despite lengthy discussions of those statements, the statements were not included in the school district's official meeting minutes that were emailed to him. The father alerted the school district to the omissions and inaccuracies in the meeting minutes. The father objected to the school district's minutes as an official record of the meeting and requested that the meeting minutes be amended to include the omitted positions. But the school district refused to do so. 6 months later, in September 2022, the father attended another IEP meeting online. He requested that the school district video record the meeting because of the school district's previous failure to produce accurate minutes of prior meetings and refusal to correct those errors despite obligations to maintain accurate records. The school district refused his request to make such a video recording, stating that making such a recording would be invasive and was not permitted by the school district's policy. However, the school district did offer to audio record the meeting instead. The father told the IEP meeting chair that since the school district's policy prohibited the school district from video recording the meeting, he would make his own recording. Once the meeting began, the IEP team meeting chair announced that they were audio recording the meeting, and the father stated that he was video recording it. At that point, the IEP team meeting chair stated that if the father did not stop his video recording, she would end the meeting. When the father refused to stop the video recording, the chair terminated this meeting. Days after the failed meeting, the father filed a lawsuit asking the court to decide whether he has a legal right under the First Amendment to record the IEP meetings. What do you think? Does the father have the First Amendment right to video record his child's IEP meeting? The U.S. Court of Appeals for the First Circuit agreed with the district court that the father had no First Amendment right to video record IEP meetings. This is because an IEP team meeting typically does not take place in public forum accessible to everyone. A First Amendment right to record public officials performing their duties only when those duties have been performed in public spaces. What are considered public spaces? They're generally areas that are open and accessible to the public, such as public parks, sidewalks, and public squares where people have the freedom to move about and express themselves. They are the areas where the public has unrestricted access and can freely observe and record activities. For example, you can video record police activities in public parks or during traffic stops on the public roads on the condition that you don't interfere with the police officer's ability to perform their duties. Here is another example. A journalist attended and video recorded a public meeting. After the meeting, he did not turn off the camera, and he continued to record as the public officials were having a conversation in the hallway of the town hall. The government officials and the police asked him several times to stop recording, but he persisted. He was then arrested by the police. The court ruled in favor of the journalist and concluded that his First Amendment rights were infringed. This is because he was engaged in recording in what was considered a public space, a hallway of a town hall after a public meeting. His activities were peaceful and within his First Amendment rights because they were conducted in a public space when public officials were performing their duties. All of the public spaces I've mentioned, like public parks, public roads, and the hallways of a town hall, are very different from the private and the controlled settings of IEP meetings, which are confidential and designated to discuss sensitive individualized educational plans. The IEP meetings are held in private to protect the privacy rights of students and to create a trusting environment where detailed and potentially sensitive discussion about a student's educational needs can occur without fear of public exposure or misunderstanding. Even if the IEP meetings were conducted in person rather than online, access would still be restricted. School settings inherently have controlled access policies to ensure safety and confidentiality, particularly during educational meetings. The general public cannot simply walk into a school and attend a meeting that has detailed discussion about students' educational needs. Those meetings are usually held in private areas in the school, such as conference rooms or administrative offices, which are not open spaces for public access. Even school board members do not have unrestricted access to school buildings. Moreover, even parents who have a vested interest in the educational proceedings concerning their children do not have a constitutional right to attend meetings if they are not explicitly invited to. In this case, even assuming hypothetically that the father had a First Amendment right to video record his child's IEP meetings, which to clarify, he did not, he still cannot record the IEP meeting. This is because even protected speech is not equally permissible in all places at all times. The right to video record can be subjected to reasonable time, place, and manner restrictions. In this case, the school district's policy that prohibits video recordings of IEP meetings had been developed with a focus on neutrality regarding content, meaning it does not favor or discriminate against any particular viewpoint. The policy is strictly operational and procedural, aimed solely at preserving the integrity and confidentiality of the discussions. This content neutrality is important because it ensures that the policy serves all participants equally without influencing or changing the discussion based on any external factors that could arise from recording being made public. Moreover, the school district's policy is designed with the purpose of serving a significant government interest, which in this context is the facilitation of open, candid conversation during IEP meetings. In those meetings, educators, parents, and specialists come together to evaluate and plan the educational needs of students with disabilities. The privacy afforded by prohibiting video recordings encourages all parties to speak freely and honestly about the student's needs, challenges, and progress without fear of public exposure or judgment. This openness is important for developing IEPs that comply with the federal mandate to provide a free, appropriate public education under the Individuals with Disability Education Act, IDEA. The school district also provided alternative methods for documenting IEP meetings. For example, audio recording instead of video recording. With audio recording, relevant information can still be preserved without compromising the quality and the privacy of the discussions. The alternatives support the educational needs of students and the parents' First Amendment rights. What can educational administrators learn from this case? Of course, parents do not have the First Amendment rights to video record IEP meetings because they are not held in public spaces and are not open to the general public. In this case, the parents' video recording request came after the school district refused to amend the omission and inaccurate information of the IEP meeting minutes. If the parents' request was valid and the school district refused to correct the meeting minutes, the school district did breach the parents' trust in schools. If the school district has legitimate reasons for not amending the meeting minutes, they need to communicate them with the parents. In situations where disagreements over records arise, it's important for school administrators to remain open to dialogue rather than outright denial of parental concerns. Adopting a collaborative approach can help resolve disputes amicably and maintain trust once trust is compromised, especially through actions that suggest deception, negligence, or disregard for mutual respect and transparency. Restoring that trust can be very challenging.